To meet this responsibility, the RSP conducts workplace safety inspections and job hazard analysis and coordinates the work of agency risk management representatives. ORM's insurance program reduces the exposure to risk on behalf of the district's government by procuring insurance for the district and by ensuring that contractors working with the district have adequate levels of insurance in the event of harm or damage. The tort liability program receives, investigates, and attempts to resolve tort claims filed by individuals against the city for property loss, damage, or personal injury. These claims most often involve potholes and auto collisions, but also include slip and falls, other bodily injuries, and more recently, claims against the city arising from protest events. The Public Sector Workers' Compensation Program works with district government employees that are injured on the job to provide lost wage benefits and appropriate medical care. The Workers' Compensation Division receives and reviews claims by employees, manages ongoing care and medication, and supports employees' return to work as soon as medically possible. I look forward to discussing this important work with our Chief Risk Officer and ORM Director, Jed Ross. I normally provide a lot of logistical updates for our public witnesses, but today we do not have any public witnesses, and I don't see any attendees that potentially might want to join. Although I will just say, if anybody wishes to join and they did not sign up, they're welcome to do so. But we do not have anybody available to do that. So with that, I'm going to turn to our director. Director, I'm going to have you take the oath. So go ahead and unmute yourself, raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
Wonderful. You may begin your testimony when you're ready.
Good afternoon, Chairperson Nadeau, members and staff of the Committee of Public Works and Operations. I'm Jed Ross, Chief Risk Officer and Director of the District Office of Risk Management. I'm pleased to testify before you today, not only as the Director of ORM, but also as a longtime district resident and advocate of district government, who believes wholeheartedly in the mayor's initiatives and vision to advance DC values and priorities. On January 9th, 2023, Mayor Muriel Bowser unveiled DC's Comeback Plan, DC's 5-year economic strategy spanning the 2023 through 2027 years. The Comeback Plan focuses on retaining and growing DC's tax base, supporting business vitality, strengthening neighborhoods, and supporting economic mobility of DC residents. The plan was shaped by input from thousands of stakeholders and analysis of trends and proven practices. The plan lays out bold goals that the district government will strive to achieve over the next 5 years with cross-sector collaboration. In keeping with the spirit of the Comeback Plan, ORM looks forward to continuing its role in improving government operations and mitigating risk. And to that end, I'm pleased to have this opportunity to highlight ORM's efforts in fiscal year 2022 and share the progress made to date in fiscal year 2023. As this is my first time testifying before you as chairperson of the Committee on Public Works and Operations, I would like to begin my testimony by outlining ORM's mission, strategic objectives, and structure. Our mission is to reduce the probability, occurrence, and cost of risk to the District of Columbia government and the residents it serves. To fulfill this mission, ORM works to institutionalize and systematize the practice of risk management within district government agencies, and to reduce the likelihood and severity of potential losses through the implementation of effective risk prevention and control strategies. We achieve the objectives by providing risk management, leadership, guidance, and support to district agencies through ORM's 4 main divisions: the Public Sector Workers' Compensation Program, the Risk Prevention and Safety Division, the Tort Liability Division, and the Captive Insurance Agency. Together, ORM's divisions work to foster a culture of risk awareness and promote risk management across our government. During fiscal year 22, one of the areas the Public Sector Workers' Compensation Program focused on was finalizing an agency workers' compensation summary report and better workers' compensation training materials. The report highlights important claim data and provides a broader audience beyond just an agency's workers' compensation coordinator. and awareness of successes and needs for improvement in workers' compensation matters as well. The report is particularly useful for annual workers' compensation reviews with agency leadership at all agencies with active workers' compensation claims. To support these efforts, newly created training materials were disseminated to managers, human resources coordinators, and timekeepers to assist with training employees and supervisors on the workers' compensation claims process. PSWCP, the program staff, conducted several training sessions about the agency workers' compensation summary report with these stakeholders, as well as agency risk management representatives, using the newly developed supporting materials. The goal is ultimately to minimize injuries and consequently to reduce the number of claims. In fiscal year 22 was also busy for ORM's RPS division, which began rolling out its Drive to Zero online training program via DCHR's Percipio training platform to a select audience. The goal is to roll out the training program to all employees who operate a motor vehicle. Passing the training will be required of anyone seeking to operate a DC government vehicle. The modules are designed to heighten awareness of common road hazards and the difficulties of city driving. They also aim to provide guidance for reducing and or eliminating automobile-related fatalities and injuries in the district, the ultimate objective of the Mayor's Vision Zero program. RPS has also been working to expand the types of incident reporting and the number of participating agencies reporting incidents, enabling ORM to better assist with understanding and mitigating associated risks. In fiscal year 22, the tort division built a contingent liability platform to report agency legal issues and pending disputes in ORM's enterprise risk management system, ERISC. The platform standardizes the process and promotes continuity, management, and payment of contingent liability claims. Another initiative involves the tort division's increased subrogation efforts. The tort division is working with agency partners to improve communication and processes to recover the cost of damages caused by third-party tortfeasors to district property and for the care of district personnel injured by them. I'm proud to say that ORM has already collected approximately $7.2 million during the past 6.5 years since the agency has made these recoveries a priority. And I'm looking forward to continuing increases in collections. The district's captive insurance agency has been diligently working to better assess the district government's risks and how to transfer such risks to third parties when possible. The agency is working to develop processes for district agencies to work with ORM to better manage associated claims with the district's insurance policies. In fiscal year 22, the captive also continued to be an excellent vehicle for local community health clinics to obtain subsidized medical malpractice insurance, and when needed, to procure insurance for district agencies. Finally, the captive works to continue with district government agencies to standardize insurance requirements where feasible. These requirements often need revision due to changes in the insurance marketplace and related exposures. However, where implemented appropriately, they provide consistency and transparency for both district agencies and their third-party partners. Looking forward to fiscal year 23, ORM has 5 top priorities. 1, customer service. 2, tracking contingent liabilities arising from litigation. 3, increasing collections against third-party tortfeasors. 4, insurance claims management. And 5, expansion of our enterprise risk management program. With respect to customer service in fiscal year 22, ORM handled 3,066 customer service calls and scored nearly perfect in assisting all of those calls in 3 rings, scoring a 99 out of 100. ORM conducted 42 customer service surveys in FY 22 and earned a score of excellent or good on 31 of the 42. We are working to expand the reach of these surveys and improve these scores in fiscal year 23. Significant measures were taken to track litigation and categorize related exposures in fiscal year 22. This process will assist agencies on the proper use of the settlement judgment fund and streamline and capture the approval process for litigation settlements. As previously stated, collection efforts against tortfeasors have greatly intensified during my tenure. The TOR division will continue its efforts to create strategic relationships with district agencies so Orem can better assist with damage recovery. A new objective relates to insurance. For fiscal year 23, Orem plans on developing a claims management playbook that lays out the strategy and roles for employees in the event of a major loss for the district. The final objective for fiscal year 23 encompasses the expansion of our enterprise risk management program. Prior fiscal years, Orem worked with the Department of For-Hire Vehicles and the Office of Unified Communication and our own leadership to develop 3 ERM pilots. Orem met with each agency to discover risks, rate those risks, and work on mitigation strategies. Orem plans to work with the Office of the City Administrator to send out survey inquiries to agencies regarding risks to better understand where agencies see their risk and how we can assist. Chairperson Nadeau, I'm very fortunate to have so many dedicated and hardworking civil servants at the agency. While our agency is less public than most, we do a significant amount of work in support of all district agencies, including the council, to better support government operations. The agency is fortunate to have the support of the administration, and we hope this committee to continue the great work we are doing. Orem will ensure that the channels of communication with you and your staff remain open and productive, and I'm happy to answer any questions you may have.
Thank you so much for your testimony. It's great to have you here, and I will dive right into questions. And if we got some of them, it may have been answered already in your testimony, but I may ask them anyway, just so we have them kind of in an organized fashion.
Happy to do so, Council.
Okay, great. I want to talk first about efforts around workplace safety and identifying hazards in the workplace. So during fiscal year 22, how many worksite inspections or risk management assessments were conducted by ORM?
So we had 156 proactive inspections, and then we responded to a significant number of, we responded to 81 workplace concerns. And so we went out to the agencies 230 sometimes during the last fiscal year.
How many investigators handle these inspections?
So we have 3 occupational safety health inspector positions, but we went through some turnover. Some people left the agency, and we were not fully staffed for much of last year. I will say this year we have, we recently brought on board 2 of those positions are now filled, and the 3rd position I think is being filled very shortly. Interviews have been conducted. So there are 3 total positions.
Great. You mentioned the 2 different types of inspections. You said proactive and also workplace concerns. So how are these inspections initiated? Are some of them statutorily required? Are they all by complaint?
No, so the agency sets out a goal to try and attempt to see as many buildings as we can in a year. And then we work to identify them and divide them up amongst the staff, and including the program administrator who oversees it. And then they'll go out and they'll proactively do inspections. So we do that regardless of any complaints. And then, of course, as complaints or workplace safety concerns get raised to our agency, we go out, we look at the location, and we'll reactively respond when there's a health and safety concern. You generally try and hit all the biggest agencies with the most employees and the locations that you would imagine, visiting the Wilson building or the Marion Barry building here where I am, where there are lots of agencies and lots of employees. We try and get out and look at those buildings proactively every year.
And what are some of the hazards you typically observe?
Generally, we'll see that, if there's been storage blocking a doorway or something that looks unsafe in that regard, or if there is a temperature concern, or oftentimes there are just building maintenance issues that need to be resolved. But we'll also look for slip, trip, and fall hazards, and we'll try and identify those. So it runs through the gamut, really looking for anything that could impact the health and safety of our employees, of course, to reduce workers' compensation claims in the future.
Is there a report that's completed after the inspection?
We do inspection reports, and they're inputted into our e-risk system. Yes.
Great. Does ORM track sort of repeat issues or identify agencies with higher numbers of hazards?
So yeah, we will look for we will look to see if those agencies are having problems. Mainly what we try to focus on is the actual particular issue, and then we will look to see if there are a bigger number of those same issues, and then we will have a global conversation about that. You know, if there's something affecting the same thing over and over in the same place or in the same area or the same agencies, we'll take a look at that. But generally, we try and look at it as an issue specific thing. And as you can imagine, with the large number of buildings we have, no one particular issue is the same. No particular concern is the same. But if we can find a trend, we'll definitely identify it. And then we'll work with our partners at DGS and other agencies in order to help address those concerns. We have really great partnerships, and our partner agencies are fantastic at following up. We work really hard with them.
Right. Let's turn to one other tool to promote workplace safety, your emergency response plans. First, can you walk us through what an emergency response plan is and which district agencies are required to have a plan?
So yes, the district agencies are required to have an emergency response plan for any building that has 8 or more employees. So it's not always, they're not always government owned. They might be leased, they might be owned. And so any building where there are 8 or more employees, an emergency response plan is required. Within that emergency response plan, it itemizes the actual layout where DC government employees are or members of the public might be. And then it will also lay out what should be done given the different potential emergencies, whether it's a fire, whether it's an earthquake, a tornado, a flood, you name it. Some have even listed volcanoes. And so whatever the potential emergency is that people need to be prepared for in order to protect life and safety at that moment, right at the event and really shortly thereafter, those details are laid out. How should the agency go? Who's responsible for the agency getting the employee details about who is in the office at that time, and are they accounted for? Are they safe? Do we need to let the fire department know? Do we need to respond in a particular way? Are there any individuals with disabilities who need special support? And all of that coordination information is within the emergency response plan. What I will tell you is often from year to year, they don't change very much. As a result of our physical layouts being the same. So there may be updates for the people if people have changed, but when agencies undergo renovations or other changes, then they need to, of course, update that information. So the Office of Risk Management will work with the agency risk management representative, call them ARMRs, and we will make sure that those individuals are getting us copies of every location where they have 8 or more employees, a copy of their emergency response plans. We will go through it with that staffer, and then they will coordinate on behalf of their agency, and then we make sure that it's accurate, and then we forward that along to FEMS, who has a review process to make sure that they are still appropriate. And then we have that data in the event of an emergency that, whether it be FEMS or even if it were MPD, they could go and get that information. These are confidential data points because they also talk about active threat situations. And of course, we want to make sure that third parties don't understand what DC government employees are doing from a safety perspective. So we make sure that everyone's going through the right process. So that is our ERP process. I will also say that during the pandemic, it was obviously a challenge in terms of getting a lot of the agencies to get the data and the details, and people weren't always in the office. However, we've been ramping that up through our risk management council meetings. And so we look forward to getting back to where we were before. We're getting, very high numbers of compliance.
Great. Okay, so you were getting to that, then to getting back up to high numbers of compliance, because it seems like just about half the agencies have the required plans right now. Is that accurate?
Yes, although I will say historically we've gotten them from the agencies. So, and there haven't during the pandemic been that many changes, but any agency that's undertaken renovations or other changes, we'll need to work on that. We've already had a training on it in this fiscal year. We're already following up with everybody. So I feel pretty confident that we'll have much better numbers for the next year. It is a challenge and a concern. Obviously, it is a large, getting the details of every building where we have 8 or more people is not a simple task. And obviously, these emergency response plans are very detailed oriented and require a lot of work and effort. So once they're done, it's really kind of fixing them to make sure that the data is accurate. But a new one, or even some of the very old historic ones, can be a big challenge. But we work through that and we partner with people and provide great support to our agency partners so they know what they're doing and help them usher through that process.
Is there sort of a deadline for them or anything like that?
We aim for the end of the fiscal year for every year. So that is our goal, which oftentimes you'll find, we'll be getting them in that last quarter. And also, if we received it in the prior year at the end of the last quarter, it doesn't make sense to then just give it to us 2 months later in the first quarter.
Got it. So they have to do it annually?
It's an annual process.
Got it. So they would have an old one on file. They just don't have a current one.
Usually that is the case, correct? Yes.
Are there any agencies that just have nothing on file right now?
To my knowledge, most all of them have something. We've worked, over every year, we've worked everything. But if it's a brand new location, it might not have one, and we would need to work with them. And if there are some historic locations and say employees now moved into it, then that's another concern that we would have to address. So, but generally, I think we're pretty solid in that everybody has one for the most part. There are some outliers that we continue to work with them on.
Okay. I do want to have you share some of the good work done by the Risk Management Council. What does the council do, and who is on it, and what's its role in government?
Sure. So the Risk Management Council actually is all of our agency risk management representatives. And so it's all the people focused on risk management within the different agencies. So every other month, we bring everybody together virtually or in person, and we have a conversation about issues that are pressing within the agencies or things that we need to educate agency risk management representatives on. And so, for instance, we've had meetings on our driver authorization forms. There are over 1,000 district government drivers. We want all of them to submit an authorization form to us, which we review and we validate that they have active driver's licenses. So we'll do trainings on that. We'll have conversations on that. We will work on talking about how's my driving complaints that we're getting. We've actually had MPD came in and did an active threat training along with HCMA and FEMS in person in order to talk to all of the agency risk management representatives. And we'll talk, we've trained them on how to conduct a proper worksite ergonomic assessment of a workstation. And then we'll just talk about whatever other risk management issues are coming up. We'll elicit from all of them things that they want to know about, and then we'll set up trainings. And then we'll also, of course, share information, lessons learned amongst everybody. So that's what the Risk Management Council is and what it does. It's spearheaded by our program administrator for the Risk Prevention and Safety Division, Pat Healy, and does a great job. It's every other month. It doesn't sit on an exact schedule. It's really got to be coordinated based on all these government employees and when their timing is, but we make sure to touch upon really important topics for all of them.
That's good. How many people is that?
There's around 50 people, so we could have anywhere from 25 to 50 people attending at a time. So it's a nice group, and they're all doing the really important work of safety and health matters for their agency, and just coordinating any issues that come from the Office of Risk Management, even if it's not just safety and health, say it's responding to claims or whatever it might be. They are kind of our liaison at those agencies, and this is a place for us to talk through all those issues.
And do they meet in person?
So we did meet in person for the active threat. We historically used to always meet in person. During the pandemic, we've turned to virtual. And what we've also found is we, of course, have a lot more participation. People don't have to travel as much. So it actually is a really good benefit. We can, of course, show everything on the screen. We can send everything out. So we're mainly virtual, but obviously whenever there's something where we have to physically show people, we of course have it in person. And the team, I will tell you, all the ARMRs are really dedicated individuals. If you can imagine, these are the people who care about people's health and safety. They are in those roles generally for reasons. The last thing I will say is there is a gamut of other duties is assigned. For some of the smaller agencies, of course, their risk management representative might be somebody who does other things when there's only 10 employees at that agency. But when it's a larger agency, they have professional dedicated risk managers who that is their entirety of their job. So just, we kind of have to cater to the people who this is another additional duty, something they have to coordinate for the agency whenever it rarely happens. And then there are some who live and breathe every day, health and safety and other risk management matters.
That's so interesting. Well, yeah, Zoom does seem like, or virtual does seem like it would be better for that group in particular, but.
And of course, with teleworking, 1 or 2 days a week at certain agencies, it also gets to be a difficult challenge to manage.
Oh, yeah.
So virtual oftentimes can be a better process for us.
Scheduling. Yeah, that's interesting. Okay. All right. So let's talk about tort liability. Yay.
Happy to discuss it.
I know. No one ever has said that before, right?
People have said certain things about potholes, maybe, but otherwise, no one has said it like that.
Not like that. All right, so let's talk about it in a way that's interesting to more than just the lawyers. When we talk about tort liability, does this mean that members of the public can sue the district government?
The answer is they can, yes, and there is an administrative process. They are obligated to file a claim with our office, the Office of Risk Management, within 6 months from the date that they were injured or knew that they were injured. Otherwise, they are barred from bringing a suit against the district. It is our 12309 statute. So it's DC Code 12-309, and it discusses this obligation and requirement for people to file claims to their office before they bring a suit. The goal and the purpose is that we will, of course, manage and respond to that claim in order to resolve it so litigation doesn't necessarily incur. This is our tort claim process, and that's for unliquidated damages. So if it was liquidated, meaning without going into too much legalese, but if it was a specific dollar amount, in our contract that said how much somebody would owe, this isn't the right place for that. But for any unliquidated damages claims, they're obligated to file them with our office. There are some constitutional claims where they're not obligated to file with our office, and those can go straight to Superior Court or to the courts to file a lawsuit. So for the vast majority of our tort claims, they file those with our office, and then thereafter we hopefully can resolve them. But if we're unable to, then the constituent who filed the claim claiming damage was done to them or their property, they can then bring about a suit against the District of Columbia.
Do you know what the total cost to defend the district in court was last year? Or I guess that would be going to OAG, huh?
Yeah, I'm not really 100% certain about OAG's cost, but I can tell you that the fund that we have available in order to make payments is around $28 million a year. But to be clear, any district dollar is available for a settlement. So that is just kind of a budget funding mechanism. And in the event that there is additional monies needed beyond that, of course, any and all district funds are available to pay the district's liabilities and obligations, whether court ordered or through a settlement, you name it.
Right. These claims are the claims that we're talking about are filed through ORM. Do you ever deal with claims that are filed through Superior Court, or at that point it's long gone?
So generally, the Office of Attorney General will manage all litigation. So they will handle the matters that are actually pending in Superior Court. They'll assign attorneys within the appropriate divisions of OAG, and those individuals will respond and defend the district. That said, we do coordinate, we do work with the agencies. They, of course, work with those agency clients who were the ones being named in those matters. and they will work to address it. And of course, the Office of Risk Management participates wherever. However, we do a good job of meeting with the Office of Attorney General on a monthly basis in order to discuss ongoing confidential litigation matters, in order to coordinate on different things. So they aren't necessarily just gone. And then we will also, I as the Chief Risk Officer being responsible for the settlement and judgment fund, will also follow up as it relates to certain matters over certain dollar thresholds. And of course, the mayoral approval has to happen when it exceeds certain dollars.
Great. Okay, that makes sense. All right, let's just list out for everybody what kind of loss or harm can a person file a claim for to be compensated?
So I think there are probably a number of different ones, but I'm off the top of my head, which I will explain. If your vehicle gets damaged on a road and the district government had actual notice or constructive notice and failed to repair that particular issue within a timely manner, generally around 72 hours, then we potentially become liable, and we would settle that
72 hours. I have sidewalk trip hazards that have been open for years. All
So,
right, now I know
yes.
who to go to.
So, well, ultimately, it's going to be the agency who has responsibility over that particular matter. But we have to have knowledge of the particular issue and have that then responsibility to fix it. For instance, if a third party truck dropped something very large on the roadway and somebody drove over it and it hurt them, obviously the district government doesn't have liability because we had no notice, we had no ability to correct that particular issue, and it becomes a tort claim between the two private parties that caused it. This also happens with our contractors. So if a contractor for the district, is negligent in their acts, then they're the responsible party. So one tort claim could be as simple as a pothole. The more sophisticated ones could be more complex property damage involving, construction issues related to district government, work or whatever it might be. And the really terrible ones that we all, are concerned about is when somebody might get harmed, or there might be a shooting when somebody would die. So the claims can really run the gamut, from as little as just a minor property damage of $50 all the way up to a loss of life. So can be really, really complex, and it's a very busy office. I have really fantastic colleagues here at the Office of Risk Management who do an excellent job of managing all the claims. We get lots a year. They provide one-on-one service to every single individual and work with those agencies as the intermediaries to try and assess our liability and come up with a resolution. So very, very fortunate to have such great team members and colleagues here.
So let's go back to trip hazards again for a minute, because I think it's very understandable for people. So let's say, for example, on 14th Street around Harvard, there's a sidewalk that a group of people has put into 311 over and over again. They sent it to my office. DDOT definitely knows about it. And then lo and behold, one of our seniors trips, breaks her wrist. This is not an actual case, so I'm not trying to get anybody in trouble.
Sure.
The sidewalk is, the tripping is not. So that senior could then sue the district. Is that 311 entry and the engagement by my office enough evidence to your office that the agency knew?
Yeah, if a 311 matter gets reported and it's in DDOT's records, if it gets into our records, it becomes notice. And if the resolution doesn't get solved, then the District of Columbia could be liable, and they would file a claim before they would sue. But if the claim doesn't reach resolution, sometimes individuals will make demands for millions of dollars for things that were, a $50, something got broken, their headphones got broken by a DC government employee accidentally. Mm-hmm. And if we can't reach a settlement, then they can bring we would deny the claim and they can bring a lawsuit. So in that particular instance, if there's a longstanding sidewalk problem and DDOT is fully aware of it and they've been unable to get it corrected, then and somebody were to get hurt, they could file a claim with our office, and we would manage it with personal service and ensure that we get all the facts and the data. We would investigate it, and we would analyze whether or not we had liability. Sometimes there's contributory negligence, meaning the individual, is doing stuff, or right. If we get medical records.
She was on her phone. She was whatever. Yeah.
whatever the particular facts of each instance, we will work with that individual and we'll try and assess the damages and the potential viability of the claim to accept or deny liability.
Okay, so are you familiar with the phrase service level agreement in 311
I am familiar with service level agreements globally.
globally? Okay, so let's just back to the sidewalk tripping, right? So if you put in a 311 request for a sidewalk repair, it's something like 240 days that the agency has to resolve it. That's not exactly the number, but it's a long time. Whereas for a pothole, it's less than a month. Do you have the opportunity to advise agencies on the length of time that they? Yeah.
So no. So the obligation is for the government to have a reasonable amount of time in order to correct a particular hazard or concern, right? You know, we can't be held to some higher standard than what's reasonable.
Mhm.
And so it's our obligation to correct and fix things when we reasonably know about them. And if we breach some duty to that individual that then has caused them harm, then we could become liable. I mean, the facts and the circumstances have to be analyzed in order to correct something. So, you know, it could be some massive capital improvement project and somebody notifies us about a particular issue, but is it reasonable for us the next day to go and fix it? No, right?
No, but okay, let me put it this way. I mean, you guys are the legal side of things. You know, DDOT is the client, right? So it could be a good idea, let me say, to say to client DDOT, look, you know, people are going to trip and fall if you don't fix this. Maybe shortening the window to 30 days as opposed to 240 days would be better for, you know, the public, our liability, all of it. Just because DDOT says, oh, this should take us 240 days. I mean, how do we allow risk management to drive some of the other policies that we've put into place throughout the city and perhaps even the budgeting for those items? I think it seems like, I mean, you could be in the driver's seat for a bunch of things that would really improve city services because that liability factor really does make a difference.
Sure. I think when we regularly identify things where there are significant financial impacts to the District of Columbia, clearly it elevates to a concern where we need to address it. I'll say, you know, DDOT's been doing a great job. They just put out their Pave DC
Yes,
plan.
I'm a fan of Pave DC.
Yeah, and so it itemizes and details all of the good work that they're doing, and it also shows our constituents and our residents where they're planning to fix things, what things are being done. There are, you know, miles and miles and miles and miles of roadway and sidewalks in the District of Columbia, and so being able to fix everything all the time gets to be quite a challenge. So one of the things that they have to do is prioritize the things that are the most unsafe and also the things that could have the biggest impact, which, as you identify, financial impact could be one of them. But not only that, we of course want our residents to be safe. You know, I know that's in the Mayor's Vision Zero plan. I know that that's what DDOT wants. I know that that's in our district values. And so, you know, I don't think there's ever a purposeful goal or to not attack something to solve that particular problem. And when we do become aware of it, we at the Office of Risk Management, we reach out to our partnering agencies in order for them to solve it. And they're always responsive to us.
Mhm.
Are they able to, you know, drop everything that's already in this plan that they've committed to? Not always, but wherever they can, they've been more than willing to try and address it in order to minimize financial harm and ultimately, you know, people's physical harm, right? So
Sure.
we're in a pretty good spot about it in terms of our partnership with them. And of course, they have their mission, they have their goals. They are the experts in strategically driving. That doesn't mean that we don't participate and we don't have our conversations with them when we see regular concerns around sidewalks or whatever that might be. If we see particular issues, I just the other day saw 2 concerns in Ward 2 and I raised them with DDOT, or if I get a constituent who reaches out to me, I will raise it with them as well. But it's, you know, I'm going to their constituent services people, just like any other resident. And they know that this is a potential financial liability and a tripping hazard where somebody can get hurt. So usually they try and address it as quickly as they can.
And I'm picking on DDOT, not because they're not a good agency, but because they really do have a lot of turf to cover when it comes to open service requests and really everyday interactions that residents have. The other big one that's actually in our cluster is the Department of Public Works. So let me ask if this kind of thing would be a claim, or if it's just if it goes somewhere else. We've heard this a few times recently where a residence can is not only emptied but taken along with trash for some reason, and just it's gone, and then the resident ends up on the hook paying for a new can, which is both expensive and difficult to obtain because of supply chain issues. So in that scenario, is that the kind of thing where the resident can file a claim with ORM?
By all means, they can. What I will say is it gets to be a challenge for we have to have some type of evidence.
Oh, there's always video.
Right. So, I mean, if there's evidence and video that it was taken by a DC government employee and it was damaged or was, they can file a claim and we'll pursue that particular process.
Oh, interesting. See, now I'm just having fun. Okay.
Yes. And I will say, council member, I am personally aware of cans missing. So I understand. And I personally have had to go and resolve that matter individually, but no claims were filed.
Well, this is why we make all of our directors live in the district so that you can feel the same things that all of our constituents feel.
I think it's an important thing. We all are constituents and we all care about the taxpayer dollar and everything that we do. So I think I'm again proud of myself and the entire agency that we take it really we consider the financial ramifications to the taxpayers, the fisc, and the safety of our employees and the safety of our residents every day, because we are those people.
So based on the data your agency receives, what are the most common types of claims?
Definitely potholes.
Okay. So
although I will tell you, council member, sorry to interrupt, there were reductions during the pandemic when there were less people on the roadways, and DDOT, of course, was able to fix things. So, but we're back to where
so much road work done during the pandemic. It was amazing.
It was great. It was great. But we are back around the pre-pandemic levels for pothole claims. In a couple of hundreds.
So this explains the dramatic increase in FY22. It was because of the pandemic.
Exactly.
So it was 22 kind of comparative to 19?
Much more so, yes.
Okay.
Exactly. And 18 as well.
Okay, now I feel like I'm getting to the meat of this, back to our DDOT stuff. So you think there's any correlation between the service level agreements on potholes being done in 30 days and the fact that we get more claims on potholes? Is that like that drives some of it?
No. So, I think some of it's around education, residents knowing whether or not to be able to file a claim, although plenty of people know to file claims. We get, well over 1,000 claims filed at our office. We also made it easier by creating an online portal for people to file during the pandemic, so they can report instead of filing in person or via paper. They can actually just send in the claim electronically. I think that it just honestly, one of the things that individuals always raise to us, whatever it might be from a risk management perspective, is around how many losses did you have? How many claims did you have? How many incidents did you have? And one of the challenges that I always explain is about whether or not you can't control what may or may not happen. And so, for instance, trucks around DC might be dropping a bunch of stuff and it might be damaging the roadway. You never know when an incident or loss may happen, and you never know how severe that incident or loss may happen. So one year we could have a really significant injury to a DC government employee that could cost millions of dollars. And another year you could have a whole bunch of minor ones. So we might have way more incidents and claims, but we're going to have less money spent. So you never really know. And obviously it's just our job to try and be as proactive as we can to reduce those claims, and trying to correlate that reduction based on the work sometimes is tough, but there are some apples to apples comparisons you can do, but it is never a simple process. So there's, 1 year it could be weather related, right? We have a really cold winter. We have lots of snow. We have lots of ice is going to result in a lot more potholes. I think it was in maybe 2017 or 2018. It was just that we were getting way more claims because the roadways were just in such bad shape. And DDOT was constantly behind just because of the weather. And so you really can't always assess what will be or what was without this global view of what incidents may be. So I can't really always give you a particular answer. I can tell you last year we had less claims, clearly fewer people on the roadways in the last 2 years.
Mhm.
So that's going to be a resolution around that. I will also say DDOT did a better job. So, those are the conversations around numbers and claims and financially what may happen. You can have people who have a pothole issue and their car could be very expensive, and replacing that exact thing in kind could be $13,000 versus an older car. So just really is very fact specific.
You're going to get a lot of fun questions now that you have a ward council member overseeing your agency. So, okay, let's talk about snow removal for a second. And snow emergency, snow preparedness. So DGS these days seems to, okay, you do remember snow events, right? We used to have them. Okay. So, anyway, DGS in the recent years has gotten, like, I would say, a little bit overzealous with the salt, right? I mean, it was like they've ramped it back a little bit, but I think part of it is they don't want to get accused of not doing it or allowing for a trip and fall hazard. So do we see a lot of claims around ice or sidewalks not being cleared by the government in particular?
I don't think we see a huge peak in it. I think
Yeah.
the government does a very good job, as you're aware, with the legislation around private homeowners being obligated to
Mhm.
fix their own sidewalks. That becomes probably a larger concern, as it's much more miles of sidewalks. But I think that the district has done an excellent job. I will say that the mayor has prioritized that.
Yeah.
DGS has prioritized that, and DPW have prioritized it. They've done an excellent job. I mean, we've been fortunate to have some mild snow events, but when we do have them, they're really on top of it. They're analyzing beet juice and other mechanisms that are safer for our environment, that reduce our costs. They're really kind of leading on the edge of what they should be doing. And they are also working on agreements to have people ready in advance, so we aren't competing with other jurisdictions. So I think that they're doing a very good job around it. And I have not seen a significant amount of claims, to my knowledge, that are a result of improper responses to snow events. I think that is something that we are doing an excellent job at and need to continue to do an excellent job at.
Great. So I know you'll be sad to leave the tort section of this hearing. So here we go. But could you, I'm sorry, we're not going to totally leave it. My bad. We got one more section. Could you explain in the layperson's terms what subrogation means?
Yes. So subrogation is the collection of money from a third party who's responsible. Now, in lay terms, imagine you're driving your vehicle down the road, you have insurance, somebody hits you, and then your insurance company will pay you to repair your car, or they'll reimburse you for the repairs that you made to your car. So you as the individual are done. They've paid out their obligation as the responsible party, the insurance company. And then the insurance company will go after that third party who hit your car and or their insurance company, and they will subrogate. So they'll go and try and collect the money from the actual responsible party. So we, for the district, perform that same duty and function, and we will go after anybody who damages government property. So we, if a signpost gets hit as you're driving into Washington, D.C. on 295 and it says, "Welcome to Washington, D.C." and that signpost gets hit, we'll find out about the accident report. We'll get the details from MPD, and we will subrogate. We will go after the driver, but more likely their insurance company. And we will try and collect the money. We'll subrogate and collect that money on behalf of the taxpayers, because the taxpayers shouldn't pay $6,000 to repair a nice, expensive, sign. It should be the party that damaged it or their insurance company who's obligated to pay for that.
Do you work with other agencies to collect these funds?
We do. We work extensively. We look for all the agencies to provide us incident reporting data. And so when we identify that something happened impacting district government property, we will then reach out to the agency and we'll follow up, whether it be to their agency risk management representative or somebody on their legal team or somebody in their maintenance division, and we'll find out more details about what happened. We'll try and obtain that police report or the facts about the individual who caused the harm. And then we'll go after their insurance company typically and try and recover the value and the cost of whatever they damaged. And so the agencies are regular with that. DDOT's fantastic, DPW works with us, FEMS. So, anyone who's MPD, anyone who's out there driving around the city, doing the work of the district government all the time, they have the likelihood to interact with other people, other vehicles, or any other scenario or circumstance. And when we see property damage or government losses, we will pursue those subrogation claims. We have 600 or 700 open and active subrogation matters for our tort division, going after money that the district taxpayer is entitled to. And then we'll partner with the Attorney General when those insurance companies or those private individuals will not be responsive to us to try and bring about, whether it be small claims or larger claim suits, to collect on behalf of the taxpayers.
And how much do you collect each year?
So in my testimony, we've collected over $7 million in the last 6.5 years, but it depends on the year. Just as we were talking about incidents, you just don't know when the incidents will occur. You don't know when the settlements or those lawsuits will resolve. So I think last year we collected around over $600,000. And it just really kind of depends on the year. This is specific for our tort liability division. Our tort manager, Peter Clark, and the two individuals on the subrogation team, Nicole Skopicki and Azel Espinosa, do an amazing job of following up with people and trying to get this money for the taxpayers. Any agency that has an incident or a loss that they didn't cause, we want that information and we work with them and then we'll get it. So like I said, hundreds and hundreds of these every year. The team works really diligently. I'm really, really lucky to have such great colleagues.
And how's the money in the subrogation fund used?
So generally the way that the subrogation fund was created was for the purpose of getting that money back to the agencies with the damaged property. So there are funding and budget mechanisms that have to happen to make that very complex. We do fund 2 of the FTEs around that, but the funding mechanisms about getting those monies to the right people is a bit of a challenge. But I will say is it will always come back to the general fund. It goes back to the taxpayers, and it gets used for that benefit. But it is our goal, and what we try and aim to do is get that money back to the agency who had the lost vehicle, the damaged vehicle, or whatever it might be. Obviously, we want less subrogation claims because we hope to have less incidents and losses. That's never good for anybody, but when they do happen, the team is ready to go and pursue it.
So it's really about, those funds are meant to make whole whatever was broken. There's a special purpose revenue for them, or
right, exactly. It sits within our within the captive insurance agencies fund. But what I'll say is, so if DPW has a trash compactor, a loader, and that loader gets totaled because another truck hits it, the goal would be that DPW is not going to have to come up with $400,000 to buy that. We would go and we collect that money in order to get it back to the agency to get the vast majority of that.
How would they cost? Jeez.
I think they're around $300,000 for some of them. Yeah, they're expensive equipment for sure.
Is there an estimated value of the 600 to 700 open claims that you mentioned?
I don't have the number off the top of my head. I mean, it's definitely over $1 million. It is over $1 million, and those will trickle in. Those, it just depends on when they'll close. Sometimes a lawsuit can take 2 or 3 years, depends on the courts. Sometimes they will take a much shorter amount of time and the people are more willing. Some insurance carriers are very willing to work with us. They will see that we've got the facts and the data and we make our demand of them and they send the check. Other times they say sue us, and then it requires the attorney general to get engaged, build out a complaint and follow through. There's also, you never know exactly where that matter will particular settle. So when I say $1 million or whatever it is, that doesn't necessarily mean that the insurance policy has enough money to cover it, or that we will actually be able to recoup all of those dollars.
Makes sense. You do a lot of advising on essentially property risk management, right? Because we have such a huge portfolio of properties and all of the things that go with owning property. One of the questions that I had that we've talked about before, but I would like to just talk here as well, is what's your involvement in implementing and monitoring warranties on projects? You know, we have schools that are being built, rec centers, et cetera, and then we end up holding the bag on things that we think should be under warranty.
Sure. We work very positively and extensively with our partners at DGS. We're doing an excellent job. I will also say, since we talked, I did follow up, and Director Anson is one of the only DGS directors who has ever pursued warranties and gotten them on certain issues. So I do know that they're doing that. We also are happy and work with them on being a repository for information, whether it's a warranty, insurance, wherever it might be, in order to make sure that if something does go wrong with a property, that the taxpayers can go after some third party in order to repair, replace, or pay for any of those things that have failed. That said, we always can be doing more. We can always be partnering with them. I've had that conversation, as I said, and we will continue to evaluate, document, and track wherever there is a warranty or a bond or a property matter that we can help in recovering on. So it's definitely an important factor for all of us. I think that this administration has done a much better job of updating our systems in order to be in a place where we can effectively use that information. I think there was a history in the district government where there wasn't technology in the system in order to track and manage things. Mm-hmm. So you have to try and go to a file folder in an office, and it was 10 years old and it's in archives. Where are you going to find that particular detail in order to make the right decision? So now that data is being tracked and managed. DGS has been working really excellently. Their work order management system, their capital construction projects, they've been working with their Archibus and Salesforce products. So I think they're in a much better place in order to track and manage that, where I hopefully we won't be in a position where we would ever not be able to find that warranty data. So even if we didn't find that warranty, we're more than happy, the Office of Risk Management, working in concert with their general counsel's office and the attorney general, to go after individuals in order to say this still didn't meet its threshold or the responsibility of what you should have done under common law in whatever way we would.
That's interesting. Like, that's an important update. Thank you for that.
For sure. And thank you.
I've got some questions about workers' compensation, which I know is one of the big things in your portfolio. How many workers' comp claims were filed in FY22?
I want to make sure I get you the exact correct data. So there are two different factors, just to be clear. There are incidents that are reported as workers' compensation incidents, and then then they resolve into claims. So we had 755 claims that were filed, and we had over 1,000 actual workers' compensation incidents that were reported. So an incident can be reported that somebody got hurt and they thought it was something, but really that individual is okay. It resolves in a day, and it actually doesn't turn into an actual claim.
Did you say 725?
755, yeah, for fiscal year 22.
Okay, yes.
Actual claims.
Yes, and 1,000 incidents. And what's the range of injuries that, that's not, I'm sorry, let me rephrase that. What's the most common type of injury that you see in these claims?
So oftentimes it can be contusions, bruises, sprains, things of that sort are generally probably the most common. people hurt their hands and they hurt their ankles in some way, shape, or form happen very regularly, especially for our individuals who are doing physical type of activities. So I would say those are some of the more common ones. Of course, it can be all the way to very significant ones where people have brain injuries or broken bones in significant ways. So it can be very challenging and tough work. We have an amazing team who provide a lot of direct one-on-one support. I also have nursing folks who work with us who provide that one-on-one care to help explain some of the medical stuff. And then we have a really great, what we call the compensability team, that once a claim is filed, they will actually speak to the individual who got hurt. They'll speak to the supervisors and they'll talk to the medical professionals in order to evaluate whether or not it was a work-related injury and accept or deny the claim. And then we'll also get it over to our nursing team and get nursing case support for the individual so they really understand what's happening and what's being done. And we walk them through that process.
Is there now a third-party administrator doing the claims?
So no, we do not have a third-party administrator. We did for many years. And in 2018, the ORM took over the full management, being a fully self-insured and fully self-administered workers' compensation program, which I think has yielded lots and lots of great results. And has enabled us to have a lot more control. When we had a third-party administrator, we couldn't get them to update their system. And so we couldn't track certain data that we wanted. And now we have our own enterprise risk management system, eRisk, which manages all sorts of case and claim matters, whatever it might be. And now if we have an area where we need more data and details, we can add that field and then everyone will use it in order for us to do what we need to do.
How many staff members support the claims management process?
For workers' compensation, there's around 50 people who are helping, whether it's prevent workers' comp claims or whether it's respond to workers' comp claims, whether it's nursing, whether it's medical only, whether it's helping to pay lost wages, doing compliance, billing review, management. So each one of those 755 claims requires one-on-one support, review, conversations, and then communication with doctors' offices, pharmacy benefits, medical care, you name it. It sounds like it's a little thing, but it actually is a huge, large undertaking in order to provide excellent care to our injured workers who get hurt on the job.
Great. In the pre-hearing responses, it appears that the average time to resolve the claims has increased. Is there an ideal measure of timeliness for resolving the claims?
So this is an interesting fact. I actually followed up with this today to make sure that I could be responsive. I actually didn't know this was going to be a question, but I saw it myself. So oftentimes we have individuals who've been with our program for decades. And so that data point is simply when a case is resolved, or the benefits are no longer being paid, whatever that circumstance may have been, that is counting the average numbers of days that those claims were open. So it's not actually a good measure theoretically, because what it is, it's an important measure. It shows you how long some of the individuals have been receiving workers' compensation benefits, which is a great measurement. But it's not necessarily telling you whether or not our performance is improving. I will actually say our performance has been improving. You can see from when we took over in 2018, we used to have around 600 individuals receiving biweekly lost wage payments. And now we're down under 200. So there were 400 people receiving payments every 2 weeks without somebody affirmatively managing their medical care, their support, the analysis for that individual, whether they were truly injured or not, all of the factors. And so now we're really much closer to our baseline of what we should have on a rolling basis. 170, 180 out of 35,000 DC government employees who are injured. Somebody goes off, somebody comes on, we're getting 755 claims. We resolve 770 claims, 765 claims last year. The age of those claims, how long that individual had been with our program, isn't always necessarily a determining factor, except for we're finally resolving those matters that had been outstanding for years. And that's why that average number went up. And there's also fewer claims. So realistically, our new claims, that 755 that got filed, we've resolved a large majority of them already. Those individuals have gotten the support. They're medically able to get back to work. We're providing them return to work services. We're providing them vocational rehab. We're doing the things that weren't always being done with this program. And unfortunately, we still have a lot of individuals who are now in their upper years, and they've been with our program for 30, 40 years, and they're finally getting resolved through different programs and processes. And that is why that number increased.
What would be a better question to ask you to hear more about your performance and your, how that's going?
I think one of the things that we talked about is our performance. I think one data point that I am very proud of, the team is very proud of, is that when we took over, 70% of our claims we could not make a decision within 30 days of whether or not we would accept or deny liability of a workers' compensation claim. 70%. We were having to take more than 30 days to be responsive. And now we are over 98, 99%. We're right around there in being able to make a decision within 30 days. We won't always be able to do it. There will never be 100% perfection around that. The concern is, sometimes there are particular medical needs, medical issues that we can't get from the medical providers, or facts from the agencies, details where we can really make a good assessment in 30 days. But I will say the fact that every individual is being spoken to, that we're following up what we call a 3-point contact, that we're doing it right, 98% of the time, goes to show you the level of performance and responsiveness that we have. We also, my legal team has done an unbelievable job in creating our regulatory, framework and our process to enable people to have due process. So if you look at our performance, you would see that we are responding to appeals and claims and concerns through the processes within the timeframes that we're supposed to. If we aren't doing it in 30 days, it's 32 days, right? But we are getting back to people. They have avenues to hear from us at the agency and get responses. Is everyone perfect? Does everything always get solved perfectly? No, but I can just tell you with certainty that our claims team, our workers' comp team, and our legal team are doing unbelievable work. I mean, it's really kind of an understatement. People don't really realize the transformation that's happened. And they only hear about these older, longstanding claims where people were not treated well. They didn't get responses. They didn't get answers. We didn't have a process to give them a resolution about properly calculating the payments or properly analyzing the particular issues and responding. The office, when I came on board, had one lawyer, for the entire office. And so there was no ability, when you're dealing with such complex, really nuanced legal issues, which is what workers' compensation is. It's an insurance program requiring real, true legal responses where we can't just kind of guess. You have to follow the law, follow the rules, make sure we're adhering to it, have the courts make decisions. I will just say, all the performance metrics in our workers' compensation division that we lay out in our performance plan shows how well we're doing. There are things we can improve at, but the biggest factor is we went from a 70% failure rate to a 98% success rate. So if you take that swing, 160% like improvement, and we continue that every year, we hit those same numbers. Like I was saying, our administrative team is mailing out and dealing with thousands of faxes every month. And they're doing it with that. Unfortunately, in the medical world, they don't deal with email. You got confidential medical information. all medical offices only want to work with faxes.
Do we need to explain to the people at home what a fax machine is?
Right, exactly, council member. In this day and age, we still have to do faxing, and we still have to respond to faxes that come into our office.
Sure.
Piece of that mail, one fax can be 100+ pages of medical records where we're reviewing it, our legal team, our workers' compensation claims team. So think about it, for 755 claims every year. So and then we still have those old outstanding matters that we're resolving, right? We have people who've been with our system for 30, 40, 50 years, and we are providing care to each and every one of those individuals. This is a big job, and I'm very fortunate to have such a great program administrator in Jennifer Arnick and such great legal team members who are litigating and managing and providing guidance. Lots of great supervisors. Everyone who's working in this job, we've really turned it around. And anybody who raises a concern, it needs to be addressed. But I will proffer to you, council member, they are typically historic matters that have been going on for more than 5 years, more than since we took the program in-house.
Honestly, I have some cases like that too, and it makes me crazy.
I would love to come up with resolutions on all of them, and we're doing that, but we can't always solve all their problems, and it ends up being in litigation, unfortunately.
I got you. Okay. I noticed in your pre-hearing responses that one of the unmet performance objectives in FY22 dealt with workers' comp subrogation matters. So what are we talking about? We talked about subrogation a lot today, but how do we talk about it in this context?
Sure. Subrogation is also that same process where we want to find, if somebody's hurt a district government employee, we want that employee to know that if they go and we're not going to go after that third party, we want them to do so unless they assign us the rights to do it. We will be happy to do so. But in the event that that's one of our employees, we had a matter where an individual got hurt very badly. They went after that private company. They collected lots of money. And then, of course, we want to collect for all the medical expenses and all the lost wages that we have paid under a calculation. And that is, it's established in our code. We follow the process. We'll go and calculate and collect back for the taxpayers what we put out, because, of course, that injured worker has been made whole, typically through that settlement. Even if they haven't been made whole, we work out the calculation in order to collect money in order to recoup what the taxpayers have put out for, whether it's pharmacy costs or hospital visits or lost wages. So that is our subrogation process. We do notify the particular injured worker. If you go and collect other money, you don't get to double dip. You don't get to pay. You don't get paid by us your lost wages and recover your pain and suffering and all those other damages from that third party. You can't get both. The taxpayers are entitled to get recoup that amount of money. We, of course, would never take money from an injured worker unless they've had a recovery from a third party.
Okay. And it's
generally, comes remember, we're going through their attorneys, right? And their attorneys know and have obligations to remit monies or notifying them. We're going through that process, and they're bringing a third party suit, directly.
Got it. But we never go after the third party in workers' comp. We just pay out.
We meet our obligation to pay our injured workers. We follow the law. We go through that process. We won't. They can release us to do so and give us that waiver of subrogation and allow us to go after that third party. And then we would work to try and collect on behalf of the taxpayers damages that were caused by that third party when they injured one of our DC government employees.
How are liens involved in this?
So we will notify their attorney that, there's a medical lien or a cost.
Oh, a medical lien. Yeah. Okay, sorry.
Or the lost wages.
Familiar with that. Okay, so a medical lien.
We'll say, the district, council members, just to put it in perspective, some of our claims, $500, $600 million, especially over the life of paying out those claims, multiples of millions of dollars, depending on the injuries, the medical care, a 2-month hospital visit or whatever it might be, very expensive. So if there is a third party who is going to pay in a settlement to that individual, typically they would cover those costs. We want the taxpayers to recoup that.
That makes sense. So you have a lien on the payout?
So
essentially.
we will notify the injured worker and their counsel generally and say, here's the lien amount.
Mhm.
As of right now, this is how much money we've incurred to
Mhm.
put them on notice.
And that would be standard, like the courts would know if somebody is claiming workers' comp, there's probably going to be a lien involved in that settlement.
Generally, yes. I mean, but that doesn't necessarily mean that we're always being notified. We have to always, of course, follow up with their counsel, and they want to get their attorney's fees. They want to get their payment for their claimant, their client who is our claimant. So it can be a complex process, but those attorneys have their legal ethical rules in order to make sure they're remitting those amounts to the district taxpayers when they're advocating for it and claiming for it for their medical expenses for their clients.
Yep.
It's statutory, about the process.
Great. Is there an estimated total of liens owed to the district under these matters?
I don't know where we are with that. I can look into it, Councilman, right? It is I'd imagine, given the years of all of it, I'll say the majority of our claims don't always necessarily, the majority of our workers' compensation claims do not always involve a third-party tort raiser.
Sure, they're more straightforward. Yeah.
And we do not because it is an insurance program, it is an insurance coverage type workers' compensation, we don't deal with contributory negligence, right? So it might be that particular DC government employee who got hurt, it might have been their fault. That doesn't necessarily mean that we won't still pay that 66 2/3 of their salary tax free and follow through we meet our obligations regardless of their negligence. There are certain factors or circumstances where exceptions in the code, I imagine, where we wouldn't commission a crime, you name it, whatever it might be. But overall, we pay our obligations, we follow through, we give them the support that they need, and then work out the rest of that stuff on the backside. We are never in a circumstance where we're worrying about whether or not to provide somebody with their medical care or anything of that sort. In terms of that is not a decision that we make. We want to decide whether we accept or deny a claim, whether or not the taxpayers are really responsible, right? Sometimes we've had people file claims and say they got hurt when they really didn't, and then we'll get video evidence or whatever it might be. But ultimately, we are helping to make sure we're providing medical care. And then if we find out that we don't accept that claim, we would then say, the district taxpayer shouldn't be paying for your medical care because it's a private insurance matter.
Okay, great. We got some written testimony while we were live. So I'm going to give you one more question. We received written testimony from a public witness, Benjamin Douglas, who could not attend. His testimony raises a concern that was expressed in last year's performance oversight hearing that there shouldn't be separate public and private workers' compensation systems. Can you give a brief picture of the difference between the two systems and why you would advocate for one or the other?
Sure. Our public system offers to give pay increases to injured workers whenever district government employees receive pay increases. In the private sector, if you get hurt 20 years ago and your biweekly payment would have been $200 every 2 weeks, let's just say, I'm giving just random numbers, we will be paying every time there's a district pay increase, we are giving percentages. So that is going to compound to 20 years, let's just say it's 2%, right? It's compounded interest. And that individual is going to be making, more than double that amount of money, right? Versus in the private sector, it is going to stay as it is. So that's one distinguishing factor. In addition, we provide significant return to work services to all of our injured workers. We also protect people's jobs for 2 years. So they're entitled to return to their original position while they take 2 years of recovery. That doesn't always happen. It does not happen in the private sector. Generally, they just get a settlement payout and they go on their way, and that's it. So we provide return to work services where we're helping to actually support the individual. We will offer them vocational services, vocational rehab. We'll give them resume, guidance. We'll help them with typing. We'll do all sorts of things. We'll actually place them in modified work duty assignments and other district government agencies, when we have willing agency partners. So we are providing nursing support that is not always provided. I will say generally is not going to be provided to the individuals. Well, when they don't know to go to the appropriate specialists, we're advising them, we're getting them into those places. We're providing all of these services that are not being provided in the private sector. And the distinctions are that it's just kind of they become a cog in the machine in the private sector. It's just an automated process. Let me see, what are your injuries? How much is this? Have you provided all the details? The attorneys, get very engaged. In addition to that, we pay the attorneys fees, 20% over and above the benefits that they recover. So we're paying that, which the private sector has to negotiate on all of those factors. So we do a lot of these different things that are not done. This is a model that was inherited from the federal government. And actually, we have people when they're pre-1980, they get 75% of their benefits instead of 66 2/3. So there are all these like rules that have adopted and changed. The council has actually looked at this in the past. Councilmember Silverman was referred, piece of legislation, didn't pursue it. And in that piece of legislation, I think some of the advocates actually proposed that there would be sports people getting, so it was literally just kind of like a wholesale change without an understanding of all the wonderful benefits that we're doing. So one thing that the advocates do raise is they talk about the ability to get care, and that they say that people should be able to go anywhere and do anything. And generally, we have a list of all the different people that they can go to. One of the reasons for that, and one of the huge benefits that we see, is that when individuals are going to members of our medical community who understand A, orthopedic issues, and B, workplace injuries, those individuals are going to be better at providing quicker, faster, and more accurate care for our injured workers, because they know what those particular issues are. They know how to resolve it. They know how they know where they should go for physical therapy, how they should do their physical therapy. They've reviewed thousands of records versus going to like a primary care physician or a pediatrician who literally doesn't deal with those particular workplace injuries. And as a result, our injured workers are getting better care. They're returning to work faster, and we're managing their matters more effectively. The final thing I'll say related to that particular thing with the medical community is they also have to follow our process. They have to fill out our forms, they have to fill out our documents, they have to be willing to write them in a way in order to comply with our legislation. And I can tell you, we will wait for months and months from certain medical providers who are not adept at these issues in order to get to the particular heart of the injury and the concern that our DC government employees are dealing with. And ultimately, the person who suffers is the injured worker. And so ultimately, the reason for this program is really smart. I mean, it was created, many, many years ago. It's in the Merit Personnel Act, actually, that this was created. It was inherited from the Department of Labor and then the Department of Employment Services. And it's taken us years to really fix and get it to work where it needs to. We've built our multi-million-dollar system in order to manage these workers' compensation claims exactly the way the law is established. And if it were to try and be changed without any thought, would be loss of millions of dollars. It would be confusing, and it would also result in less care for our injured workers and less benefits related to their pay increases that they get every year whenever other employees are getting it. It just isn't equitable. And to be truthful, as a DC government employee, I personally would rather be in the public sector. You, council member, would be in the same system. I would rather be in this system than be in a private sector where it's just a rote transactional, you pay me, I pay you, and the benefits are not conferred for protecting your job and all sorts of other things that happen. So that's what I would say. I can understand and appreciate having to work in two systems is difficult. With two complex rules of law is difficult. I understand that, but I will say we are trying to do the right thing by all of our injured workers when they're hurt. There are some long-standing, outstanding injured workers who've been with our program for decades, who, don't want things to change, and their attorneys generally are representing those. If the attorneys were representing newer claims, I don't think that they would be expressing their frustration with our regulatory process. And the last thing I'll say related to that, Councilmember, and sorry for going on so long, is we also have a lot of our injured workers who have been with our program for long periods of time. You can imagine that there are medical issues that are unrelated to their work injury that are preventing them from being able to get healthy or have it be resolved, whether it be diabetes or being overweight and they can't get a knee replacement, or whatever the particular concern might be, that are ancillary issues that we're always constantly trying to work on and support them and figure out a way to get them to where they need to be. But oftentimes our matters that are in litigation, they'll claim, oh, you haven't paid for this particular, a knee replacement. And I'm not raising any particular ones to the questioner, just to be clear, but they'll raise something that will say, oh, you haven't done this or you haven't done that. I'll say, well, your individual, doesn't have the blood pressure to be able to do whatever that particular concern is. And each one is so fact specific. It really, just talking about changing the system without any thought or even really a full understanding of what it is that we do every day gets to be a bit of a challenge. So that's what I would say in response. It's one thing that I've consistently said. And if there are solutions and resolution, whether it be permanent disability, addition of permanent disability categories, we are open. That was actually a piece of legislation that was put forward under the last council session and went to the workforce committee. We're happy to do that. What I will say is, to make a wholesale change like that would cost the taxpayers millions of dollars and would be, in my opinion, harmful to the injured workers. Are there some benefits to the private sector? I'm sure that there are. There's some efficiencies, there's some other benefits, but ultimately, if you were to weigh the scales, I think it definitely outweighs it. And I, as a district employee, would prefer to be in the public sector program than the private sector program.
Thank you for that answer. I appreciate it. That's all I got for you.
Thank you so much, Chair. I really appreciate you and the entire committee. We look forward to working with you. If you ever have any questions, happy to work through the Mayor's Office of Policy and work with you to solve any problems.
Thank you so much.
Thank you.
This concludes today's public oversight hearing. If you plan on submitting written testimony for the record, a link will soon be added to my website at briannenadeau.com/committee, where you'll be able to upload your PDF or Microsoft Word file, or you can email publicworks@dccouncil.gov. The record for this hearing will close at 5 p.m. on Wednesday, February 8th. I'd like to take a moment to remind you that the Committee on Public Works and Operations will be holding 6 more performance oversight hearings. On Monday, February 6th, the committee will hold a performance oversight hearing for the Office of Administrative Hearings. On Thursday, February 9th, a performance oversight hearing will be held on the Office of Human Rights and the Commission on Human Rights. The following week, the committee will hold a performance oversight hearing on the Department for Hire Vehicles and Department of Public Works on Wednesday, February 15th. And on Thursday, February 16th, there will be a hearing, joint hearing with the Committee on Transportation and the Environment regarding the Deputy Mayor for Operations and Infrastructure. Finally, on Wednesday, February 22nd, the committee will hold performance oversight hearings on the Office of Contract Procurement, the Contract Appeals Board, the Office of Chief Technology Officer, and the Department of Licensing and Consumer Protection. If you'd like to testify at any upcoming Public Works and Operations hearings, you can sign up on my website at briannenadeau.com/testify. The time is now 3:03 p.m. and this meeting is adjourned.